1966 ခုနှစ်မြန်မာနိုင်ငံတရားစီရင်ထုံးစာမျက်နှာနံပါတ်1139 The Union of Burma Applicant vs Mountain SEIN Respondent ဤစီရင်ထုံး audio book ကိုအထက်တန်းရှေ့နေဦးအောင်ခိုင်ဦးအထက်တန်းရှေ့နေဒေါ်ပြည့်ပြည့်ဖြိုးနှင့်တရားလွှတ်တော်ရှေ့နေဦးထိန်လင်းဦးတို့မိသားစုကစီစဉ်ဆောင်ရွက်ပြီးဒေါ်ယူပါစောမင်းမှဖတ်ကြားခြင်းဖြစ်ပါသည် Criminal Revision before ဦးစိန်သင် Judge The Union of Burma Applicant vs Mountain SEIN Respondent Penal Code Section 325 Trial of warrant case as summon case whether irregularity curable by Section 537 Criminal Procedure Code Enhancement of sentence held if the warrant case is tried as a summon case, the procedure is illegal and the conviction is liable to be set aside, but there is authority for the view that such an irregularity is curable by Section 537 of the Code of Criminal Procedure unless it actually causes a failure of justice. The respondent was convicted on his own admission, and as such, the conviction registered against the respondent cannot be said to have occasioned a failure of justice. As regards the question of sentence, it is an invariable rule that the High Court will not enhance the sentence in any and every case in which the accused person has been punished too leniently, but only where the punishment appears to be so grossly and entirely inadequate as to involve failure of justice. MAUNG and another versus MAUNG and another 1955 BLR 8C page 203 State versus Paya 18,829 CBLR 4 Criminal refer to Domyatan Nu Government Advocate for the applicant Wu Sein Thin Judge in Criminal Regular Trial number 9 of 1965 of the Township Magistrate SEIN, the respondent Mountain SEIN has been convicted under Section 325 of the Penal Code and sentenced to suffer imprisonment till the rising of the court and to pay a fine of Jet 15 or in default to suffer further 7 days imprisonment. The learned session judge of Taunji, who has taken up the case in revision, has recommended that the case be quashed and that a fresh trial order. The learned session judge has pointed out that although an offense punishable under Section 325 of the Penal Code should have been tried as a warrant case, the trial magistrate has adopted the procedure prescribed for the trial of a summon case. The sentence meted out to the respondent, in the opinion of the learned session judge, was also inadequate. No doubt, if the warrant case is tried as a summon case, the procedure is illegal and the conviction is liable to be set aside. But there is authority for the view that such an irregularity is curable by Section 537 of the Code of Criminal Procedure unless it actually causes a failure of justice. In the present case before me, the respondent was convicted on his own admission and, as such, the conviction registered against the respondent cannot be said to have occasioned a failure of justice. As regards the question of sentence, it is an invariable rule that the High Court will not enhance the sentence in any and every case in which the accused person has been punished too leniently, but only where the punishment appears to be so grossly and entirely inadequate as to involve failure of justice. No doubt, as laid down in the case of MAUNG and another versus MAUNG and another one, there is nothing in the Criminal Procedure Code which either expressly or impliedly prevents the High Court from enhancing a sentence passed against the accused by the lower court. But, as pointed out above, this court is always reluctant to interfere with the sentence passed by the lower court unless the same is so manifestly unjust that an interference is called for in the interest of administration of justice. This has been the principle followed by the Indian High Courts, as can be seen in the case of State versus p.1139, which is also quoted with approval in AIR 1935, Nagpur 117. In the present case before me, I have noticed that the lower court has taken into consideration the fact that the respondent is a first offender and that he is only 19 years of age. The offense is also alleged to have been committed on account of the provocation given by the injured person. In the circumstances, I would hold that the sentence passed by the trial court cannot be said to be so grossly and entirely inadequate as to involve failure of justice. The recommendations made by the learned session judge cannot therefore be accepted. Let the proceeding be written with the above remarks